Good morning, Chairwoman Coleman, Vice Chair Hudson, and members of the Missouri Senate Government Efficiency Committee. My name is Nino Marchese, and I serve as the Director of the Judiciary Task Force at the American Legislative Exchange Council. I appreciate the opportunity to be here today to provide ALEC's nonpartisan research and analysis. Thank you for having me. The American Legislative Exchange Council is America's largest nonpartisan voluntary membership organization of state legislators dedicated to the principles of limited government, free markets, and federalism. Comprised of nearly a quarter of the country's state legislators and stakeholders from across the policy spectrum. ALEC members represent more than 60 million Americans and provide jobs to more than 30 million people in the United States. Members of ALEC's Judiciary Task Force, which I run, include state lawmakers and policy experts who handle issues ranging from criminal justice reentry and recidivism to civil litigation and administrative state reform issues. A large part of the task force's portfolio also includes protecting the separation of powers and co-equal framework established between our distinct three branches of government, which is why I'm here today. So to begin, I'd like to touch on our members' experiences with judicial deference reform. Regarding opposition to eliminating deference, the most common obstacle our members encounter is the fundamental misunderstanding of the issue and what it really is. Additionally, there are claims that conservative parties and or courts seek to benefit and are given a leg up in the courtroom when deference is eliminated. However, because of its procedural nature, deference provides no benefit to any group or political party. But prohibiting deference does promote justice and upholds our nation's separation of powers. So what exactly is judicial deference? It's the practice of a court deferring to the executive on something courts have long been assigned the executive privilege and responsibility to handle themselves, questions of law. With deeply set roots, our legal system has determined that when the law is ambiguous, objectively or arguably, the judiciary will be the adult in the room to determine what the meaning of a law is. Judicial deference obliterates this legal framework our nation is built on by instead having courts defer to bureaucrats' interpretations of the law when an ambiguous statutory matter is afoot. Deference takes one of two forms. It's either mandatory or voluntary, the former forcing courts by law to defer to agency views, with the latter simply allowing for the practice. Missouri's particular deference status is unclear, as its courts have held inconsistent rulings on the matter. What is clear is that this legislature has yet to prohibit the practice. But what is so wrong with courts deferring to executive agencies? Employees in state agencies often dedicate their careers to developing the subject matter expertise which they use in statutory enforcement responsibilities regularly. Further, some may have a deep knowledge of the policy issues the judges are tasked with interpreting and ruling on. Regardless, courts deferring to such employees create three major problems. First, it increases the power and unjustified lawmaking abilities of unelected bureaucrats. Each senator on this committee endures the adversarial struggle of justly achieving their political power through an election, earning lawmaking authority through the consent of the governed. One of the core purposes behind our representative democracy is to ensure that those who make our laws are accountable to the public which they govern. Unelected bureaucrats are not. Nonetheless, they hold immense rulemaking powers which govern and affect the lives of Missourians. Allowing subjective agency interpretations of a law to prevail over that of a judge's effectively increases bureaucracy power because it teleports their preferred reading of this legislature's laws into the courts and into the law where they might have otherwise died in a government building cubicle. Second, judicial deference abdicates judges of their exclusive responsibility to interpret the law. Judicial review is a long-established power and core function of the judicial branch in both state and federal systems. It is well equipped to interpret the law when unclear and has many tools at its disposal to do so. Most importantly, legal interpretation is a responsibility exclusive to the judicial branch. While agency expertise on policy issues may serve as potentially valuable insight and resources to actual lawmakers like yourselves, their views have no business determining judicial decisions. Lastly, I'll just say that deference it removes the primary function of our judicial branch that it's supposed to exercise, and what society has deemed that it should exercise is interpreting law when unclear. That is an exclusive role of the judiciary. It is not up for unelected bureaucrats to decide, and it gives parties an unfair advantage in a courtroom where they might otherwise expect a level playing field. And so for that reason, we'd like to share our insight and nonpartisan research and analysis with the committee and encourage you all to revisit this issue like many other states in the country are doing. Already 8 states have introduced laws this session to reform their deference practices. So we encourage you all to join them as they reconsider this very important issue. So thank you.